All right. Hello. My name is Theodore or Tivia Sandler, managing partner of Sandler Law PA, and welcome to the Sandler Law Podcast. Today I'm joined by Peter Dubowsky, an attorney specializing in commercial collections in the state of Nevada. Peter was admitted to the Nevada bar in 1993 and has been litigating commercial and judgment enforcement matters since that time. He lectures throughout the country on a variety of judgment enforcement topics, in addition to other topics of commercial collections, ethics, Nevada judgments, and solo practice. Peter is one of the founding officers of the Creditor Rights Attorneys of Nevada, Inc., and an active member of the Commercial Law League of America and International Association of Commercial Collectors. He also has served as a Las Vegas Justice Court small claims judge pro tempore since 1998. Last but not least, and maybe the best part, Peter is a comedy performer and history lecturer. All right, so with that introduction, why don't we just get right into it here? So, first question, just tell me a little bit about your background, kind of where you started and how you got into collections.
Good. Thank you so much, Tubi, and thank you for having me on to join you on this inaugural maiden podcast voyage.
Yes, it is.
Wonderful. Good. So look, I'll tell you, uh, I'm glad you asked because I don't think I was interesting to anybody that they would even ask me. But I'm glad to talk to you about it. So I started off my practice back in 1993. How far are we going back, by the way?
Yeah, I want to start from the beginning, but kind of just a brief overview.
Okay, good. So I've been doing commercial collections since 1993. I think with a lot of people, especially guys who do what we do, no one ever started law school and say, "Oh, why are you in law school?" Oh, because I want to do commercial collections and judgment enforcement. Said nobody in the history of the universe. I don't know about you, but I went to law school in Los Angeles, so everybody in law school said entertainment law. I'm interested to know when you were in law school, what did everybody say they wanted to do?
Yeah, no, I mean, UM, it was sports law was a big one at UM.
Uh,
Miami, University of Miami.
oh, that makes sense. Yeah, that makes sense. So, yeah, so in Los Angeles, everyone's entertainment law. Now, there was actually someone who did do entertainment law when he graduated law school, but I graduated in '93, and the economy was really bad. So people just were just getting the jobs where they got jobs. And I think even today, I tell people, unless someone's really top and specialized and says, oh, I'm going to graduate, I have my science degree, I'm going to do patent. Okay, but otherwise, everybody else just looks. You go where you needed. That's what it is. You go where you needed. So I started out pretty much doing commercial collections and work with one of the top guys here in Las Vegas
So
for about 8 or so years.
you kind of just fell into it. That's who hired you, and that's how it started.
Pretty much, yes, yes. I had a job before that, which was really horrible, and I said I don't like working with this, and I was a single guy. I could just say, what, I don't want this, and took about a month or so, and I found a better job, and started doing this, and I liked it much more, and was doing it, and I said was fortunate enough to work with somebody who I was able to learn the ropes of commercial collections, the as you may have heard the word, the triadic system, and this person was very active in the commercial law league. Triadic system, as you know, is commercial collection agencies, commercial attorneys, and the law lists that bring everybody together. And so I was worked with him for about 8 or so years, and then it was pretty much time to start my own pirate ship and embark.
And how long have you been out on your own?
Since April 2003.
Okay, so good 22 years almost.
Yeah, and I kind of left out a spot because I really didn't leave. I kind of left. Uh, I left out a piece. I did leave because I got a job at a timeshare company doing collections, and that was, certain people on the highway of their career. Sometimes people take an exit. Sometimes people take a wrong turn, and then there were those people who just go sideways into a ditch. Well, I did that. I did the sideways into a ditch working with a timeshare company and just took it right in there. If I was in Florida, it would just be my career would have been a car in the canal on the side of the road.
Right.
And but I was able to, thank God, after being there for like 3 months or so, I was able to pull myself out. And that's when I decided I was the best way to go is really to start my own practice. But really, it was only after seeing that there was no other option left than to really just build my own practice. And that's with talking to people saying, this is my situation. They said, yeah, you got to build your own practice. And that's what I did. And when I started my practice, I mean, literally, it was from nothing. I had no clients, I had no money. And I took my son's crib out of an upstairs bedroom and moved it out and bought a desk, an all in one printer and got myself a phone number, fax number, email address, and the rest is history. But that's how it was started.
All right, very cool. Yeah, I mean, timeshare company is definitely not the most prestigious job out there. So,
No, and I really thought this was it because at first I thought they were offering me a lot of money, but it really wasn't in the end, and it was. Yeah, you're right. It's sleazy. It really was. I mean, timeshare companies are timeshare companies. So picture the level of sleaze, and that's the level of sleaze that I was working with.
yeah.
But it wasn't so much the sleaze, it was people there were unhappy.
Mm,
And it was just not a healthy environment. And I really didn't connect with people because there wasn't like healthy people and you're surrounding yourself with good professionals. You were there and people didn't, the people weren't supporting each other. People didn't have happy lives, and it just wasn't good. And then on top of that, you had timeshares, which are just that.
all right. So maybe just for the non-lawyers, even maybe the lawyers out there, just what is collections practice? We've been talking about it, but how would you define it?
Right. So the really collections really is in really two separate camps. You have, on the one hand, you have consumer collections, or what we call in the industry retail collections. That's people who owe credit cards, people who owe on auto loans, individuals, consumers that owe money. And then there's the commercial side, businesses, and those businesses could be individuals, guarantors, uh, uh, individuals who owe business debts. I'm in the second camp. I do not handle consumer stuff. I handle commercials. These are businesses that owe money on business debts. And by businesses, again, I mean, could be individuals, but they're individuals on business debts.
And so, how would you distinguish it from commercial litigation generally? Meaning, you hear about litigation and then you hear about people talk about collections. So, where would you draw the line?
You mean between consumer and commercial, you're saying?
No, between commercial litigation, and a lot of firms
All
will
right.
say we do litigation, but then there are firms that'll say we do collections. So,
Okay.
what are the two?
Right. So with commercial litigation, your main objective is to collect the money. So there usually there will be a dispute. You will be in contested litigation, but you're really there because the person refuses to pay.
You're
And you
talking about
have
collections now, commercial collections.
commercial
Yeah.
collections, yes.
All right.
And so you're not litigating to resolve what is primarily a business dispute. You're really litigating because the person is owes the money, or your client says they owe the money, and you have to litigate. And then the litigation doesn't necessarily result in the payment. The litigation is many times to get a judgment, and then you have to enforce the judgment. So it's not like you're litigating with on the other side like an insurance company, and then once you come to a settlement, you get a check. You don't get there's that doesn't how it goes. That's not really how it goes. Hopefully you do. I mean, your objective is to settle, but usually you're going to be litigating cases, getting your judgments, and then you have to enforce those judgments.
Right. So is it fair to say the way I kind of conceptualize it is commercial litigation is there's a dispute and it's not entirely clear who owes who the money. That would be kind of general litigation versus collections is, there's a debt here. It's pretty obvious there's a debt. The other side might come up with some excuse or something like that, but you can show on paper we performed services, we gave you goods, etc. Is that how you would distinguish the two?
Right. Usually the person is, if you're on the collection side for the creditor, usually you're coming into court because you have unpaid invoices, you have a contract where there's a balance and a breach and a balance. One of the other differences that with collections, you're covering many different areas of law. So as a commercial collection practitioner, I have to know the Uniform Commercial Code. When it comes to goods, for example, you have to know the code. And so you're litigating a lot of cases. Just hey, listen, we ship goods. Could be any kind of goods. Could be food to a local restaurant. Could be it could be other kinds of merchandise. You have to know also the UCC on leases. It may be it's an equipment lease. You have to know the Uniform Commercial Code on leases. You know, goods is Chapter 2, Article 2. Leases 2A is 2A. For a while, I was doing a good deal of commercial paper, Articles 3 and 4. I used to represent a very large check cashing company. And so I was doing a lot of commercial paper. People always in law school learn about negotiable instruments. So they go, what the hell am I learning this for? And I actually was doing actual negotiable instruments litigation. That was only for really one client. But you have to know. And then sometimes you're litigating. I represent insurance companies, and insureds owe premiums. And you have to know that area of law too. Calculation of premiums after an audit. And then there's also indemnity, usually like for bonding companies, I represent bonding companies where they pay out a loss on a bond. And you have to be able to litigate. You have to know the area of law here where, okay, the bonding company paid out on a claim. Now they go after the indemnitor, say, okay, now you have to pay us back, indemnify us for the loss payout.
And the
So
indemnitor, just to make it a little, maybe for the non-lawyers or even for the lawyers, the indemnitor is typically the one who paid paid for the bond. They put up some sort of collateral for the bond, and then the counterparty had to exercise on the bond, and now the bond company goes after the
correct.
person.
The
Yeah,
right. The indemnitor is the person who usually it's because they need the bond in order to do work.
right.
So they'll buy the bond, but then as a condition of buying the bond, they have to tell the bonding company, listen, if you pay out on a loss, I will pay you back. I will indemnify you. And it's usually the personal indemnitor usually is the principal of the company that's buying the bond.
Yeah. All right. Yeah. So it can definitely be a little more exciting than I think what you typically hear is collections is just as boring, sending out letters, etc. But it can get interesting and cover a wide variety of topics.
Oh yeah, let me tell you something. If only it was boring. No, I don't ever wake up and say, "Oh boy, just another day. I hope there'll be a new check." No, it's the blessing of the work. I get up and you have no idea when you come into the office what is coming in, and hopefully you have days where you know what you already know what you have to do. You already have this pile on your desk, and you have motions to file and research to do, and then you have then new things happening, new cases, new appearances, new attorneys you have to deal with. So yeah, it's never routine and it's never boring.
All right, and then just getting back to the litigation itself. So, you said there is some real litigation. In your experience, when you go after someone, like you said, there's an invoice or someone had to exercise on the bond. It's obvious they owe the money. What sort of defenses do the other side come up with? And, in extension of that, are they real defenses or would you call them more delay tactics or kind of technical nonsense?
No, they are across the board in terms of like I just recently got a judgment on a case I was litigating for over a year where my client mistakenly sent an email that said they said in this case the debtor was receiving services and they sent an email saying, oh, are we paid up? And my client wrote an email back saying, oh yeah, we show zero balance. Well, guess what? they quickly found out that there was no zero balance, that they didn't pay. And that email saying, oh, you have a zero balance was able to take that case and stretch it out a year of disputed litigation until finally I got summary judgment but even until the bid around, they said, but they wave it around. We got an email that says, hey, yeah. I said, yeah, but there's no proof of payment. And by the way, and of course, there's emails after saying, by the way, we don't show payment. Can you please send us the copy of the payment? No, we don't have to send you a copy of the payment because we have your email that says that we're zero balance. And again, that stretched it out over a year. So you have bad defenses. Sometimes I'm in a case right now where uh, my my client shipped goods, uh, medical goods to a clinic, and the clinic is saying an employee uh, was ordering them to steal and this and that, and which really should not be a defense that to my client. They say, well, you really should have known it, whatever. So yeah, so that one, okay, I know they really are in a dispute with their former employee, but can't drag us into it. So, and then I can see in their minds, they're thinking, why should we have to pay for this when we had an employee who was taking this stuff and starting their own business with it? And I can see that, but my client had nothing to do with that. So in that one, I could see where in their own minds, they have more of a defense. It's not just being snarky and saying, oh, look, we have an email that says we paid. Let's. So it really runs across, but most of them, a lot of times, they're just trying to push it out as long as they can. And and that's why when you do the commercial cases, you have to be very aggressive. You have to keep pushing and pushing because their job is just to say, I'm going to sit back and wait for you to ask, wait for you to push, and hopefully eventually they pay. Sometimes, but really it's you have to be in the driver's seat to be aggressive in all the cases.
Right, and when you take your cases, you talked about this briefly. Maybe you could expound on it. The triadic system, just to kind of explain what that is. And when you take your cases, generally I think it's contingency, but is that how you operate, or do you take any hourly? What's your arrangement?
No, most of my stuff is contingency. That's how the commercial collection world works. There really is nothing really comes in hourly. Now, if a case there's a counterclaim that's filed after you get the case, and then it becomes an hourly case because now you're defending in what is in essence a new lawsuit, even though it's the same case. But I don't like those. I mean, I really prefer not to have hourly. I know there's certain people who love hourly. I don't. I prefer to get the money from I prefer to give money to my client than ask money for my client. So that's part of it. But no, I think mostly it's contingency fee. And the way it works is that most work in the commercial collection industry really comes through what's called a forwarder, which is a collection agency, a commercial collection agency. And the commercial collection industry is a very sophisticated business, and their job is to get customers, and and they have to manage the file. They try to collect it before they send it to the attorney, but then if it has to go to legal, as they would call it, so now you have the client, the client's collection agency, and then you, and that's not even the triadic. Those three are not even the triadic. The triadic is the law list, which the law list is the one that would tell the collection agency, hey, by the way, if you're an attorney in Florida, go to Mr. Sandler. And they do more than just say, go to Mr. Sandler. Mr. Sandler would pays money to be on the list, and they bond Mr. Sandler just in case, God forbid, anything happens. The law list does have exposure. So, but that's usually what comes in on contingency fee through those channels.
And your cut, it's typically 20% these days, right?
I tell you, it's all over the board. It really is. I have ones I've had for a long time. I've had some ones, well, some for a long time. They're 25. I've had some that want to go a little lower. And unfortunately, in the industry, the fees have gone down because the collection agency world has consolidated, and it's consolidating as we speak. Where it used to be, there were so many agencies out there. They're all been bought up and merged, And once they merge, they start saying, okay, well, now we have this huge monopoly. If you want our business, you're going to lower your fees. So thinking, well, do I like working with them? Can I work a little bit lower? Because there are so so it goes down. I've seen it go as low as 15 on certain ones. That's unfortunately the new norm for a lot of the agencies. But 20 is, I think 20 is usually in the middle. And again, there's no agreement among them, just what's the industry standard. And the industry standard, usually 20 is good. Again, there's 18 out there. Above 20, more rare these days.
Right, and so the 20%, meaning that recovery, you would get 20%, the client gets 80, and then also the client bears costs, right? So you're never going out of pocket.
Correct. And when I say the client, let's be more clear. When the company, well, let's put together. Let's say it's a giant food company, and this giant food company has a restaurant that hasn't paid a big bill. What happens is they go to the agency. Now the agency has a cut, obviously, because that's how the collection agency makes its money. Then when the collection agency goes to an attorney, the agency still usually gets that cut. Usually gets a cut. So let's just say, for example, you get an installment payment, a settlement payment of $1,000. So let's say I take out my 20, that's 200. I send $800 to the agency, and the agency takes out their cut, whatever that is. I don't ever ask. It's not my business. I have a right to know if I wanted to, but I don't care. It doesn't affect me. And they have whatever they may have a they may also have they may take it on a third. So that means that difference between the 20% and the 13%, that may be theirs,
Mm.
and or maybe less. It may be that 25. Very rare. I sometimes have collection agencies say, by the way, we once we go to legal, we don't have any fee. I don't know why you do that, but that's how some may work it. But I think that's rare. I think so. The money has to go. I take my cut, agency takes their cut, and then the client gets the remainder.
Right. Okay. So when you're handling a case, when you kind of think of the clients, is your main contact point the agency, or is it the original client who produced the credit?
Legally, your client is the client, but the agency is their agent. So the way it works is you're really only supposed to go to the agency, and the agency is supposed to be the go between. And that's their value, is that they help you get the client to do what needs to be done to get the money. But you're really not supposed to be dealing directly with the client. That's considered a big no-no. Sometimes it has to be done. It's going to hearing, it's going to trial. And sometimes the agencies are okay with it, but normally they're not. And it's really a big no-no to circumvent the agency and be talking directly to the client. The agency's there, and the value they add is that they are on top of the file. They are the agent for your client. And you're correct on the first part too, is that the standard in the industry is that when it comes to out of pocket, the out of pocket is advanced by the client through the agency. And they may have a deal, which they may have a large trust account where they can tell the agency, okay, release funds to the attorney so they can file suit, or maybe the funds come through the client and then just pass through, something along those lines. But yes, in the industry, you're supposed to have the funds advanced, and if you do come out of pocket more, which hopefully you don't, they're really supposed to reimburse you,
Mhm.
and they should. Sometimes you have sort of process bills that spiral out of control. Those are really supposed to come, and you're supposed to get reimbursement for that, which thank God I do. I very rarely have a case where it's like I didn't get full reimbursement for some out of pocket expenses. Very rare.
Mhm.
I think of
So
only
so
one
mhm.
case.
Right. So it sounds
Yeah.
like you will, at least nominal amounts, you will advance. It sounds like because you have an understanding that you will get reimbursed.
Yes.
Yeah.
Yes.
Yeah, so kind of going back to what you said earlier, these cases that do get drawn out, it sounds like they're few and far between. I mean, I've been doing this myself a little bit, but you have a lot more experience. The ones that do get drawn out, you could be talking about depositions, mediation, etc. That could be thousands of dollars in expenses. How do those work typically with the client, the agencies?
All right, so as you probably know, when you're on this side, you want to keep the costs as low as possible. Avoiding the discovery, it really is where that's where the resources get all sucked in. So you could do some, if you have to do discovery, you do discovery. Written discovery, there are cases you have to do depositions. Those get expensive and time consuming. And again, if you're in PI cases, you have to do depositions because there's more that needs to be developed through testimony. With a commercial case, that's hopefully not necessary to develop your case through testimony. Usually, you should be able to develop your case through business records that are authenticated by the custodian of records. But yes, so really, you need to get it to judgment as quickly as possible and try to avoid the unnecessary costs or even what could be necessary costs of discovery. Try to limit those.
Right. All right. So once you do get a judgment, what's your first move?
Hopefully, it's you have some known asset. And a lot of times the client says, we don't know any asset. And I'll say, well, hopefully there's something. Did they make payments before? And and usually work with the client that tells you, oh no, this is a known asset. If there are no known assets, that's when it gets tough. And we don't have time today to go through what that process is, but that's where it gets that's where it gets deeper when you have to discover assets and it's actually getting more difficult these days to find assets for reasons that are not related to this, but it's easier to
Move things around.
yeah, move
Title
things
them in
around.
companies, fake companies, etc. Yeah.
Right. Have funds in places you can't find them, and yeah, that's more common today.
All right. So in y- in your experience, how often? Obviously, you're pushing for settlements. I mean, any lawyer, any civil lawyer is pushing for a settlement, get money through non-compulsory court action. So what's kind of the breakdown? How many of your cases end with just a settlement? They pay voluntarily. How many do you have to actually execute against an asset?
Oh boy, I really wish I could tell you a number in my head, but I do have so many cases going at once that I really don't have a sense of you know because my my docket is my caseload is a lot going to default judgment, which probably is the biggest use of resources is just getting cases filed, served, serving notices, going to default, applying for default. And then in a lot of cases in Nevada, I don't know how it is in Florida, but in Nevada, judges for cases, and this is, Nevada is a very weird place because every judge is different. Every district is entirely different. Even with the same set of rules of civil procedure, they're all very different. And it's which is really strange to think about it, but it really is true. Everybody is different, and so there's sort of like an unwritten rule. It's unwritten. It's not written anywhere. That if you're seeking a judgment for more than 50,000, the judge will set it for on a hearing to prove up, which means I go to court and it's like a trial. I have to get the custodian of records to testify to the documents. In one case, actually recently,
You need live
it,
testimony in court on a default.
yes,
Oh,
on a default to get the default judgment in cases above 50,000. And
wow.
in one case, I had a judge who said, I want I want a full hearing, and she said this is going to be a trial on a default judgment, which ironically is a company that's not even in business anymore. And I had to go, and when I was done with the testimony, and she granted everything I asked for, and she said, uh, she said, "Oh, you can sit your findings of fact, conclusions of law." So I can just submit a default judgment. She says, "No, no, no. You have to submit a full findings of fact and conclusions of law." And there were about 12 records because it was like two insurance policies or three insurance policies and audits for each policy, credits and debits. And so I think it was like maybe again probably like somewhere near a dozen exhibits that we had to go through. Which is no, no, no. I want a full findings of fact, conclusions of law, and yeah. So yeah, I had to do that, and luckily that is rare. Normally, with a default judgment, the judge hears testimony, and then the judge will sign off on the judgment, the default judgment, with just hearing the testimony. It was only twice. One time that had the full thing. So this is a trial. And the other time the judges said, "No, no, I want your judgment to be in the form of findings of facts and conclusions of law." But there weren't as many documents, so it wasn't as bad. So
Well, yeah, I mean, in Florida, I've never heard of that. I mean, I've had default judgments in excess of 50 grand, and it was without a hearing even. I just submitted it to the court and it was entered.
And
Um,
by the way, and there's nothing that says that judges can't. It just is like it's sort of like a custom that's developed with all these judges. Like somebody said, "Oh, it's 450,000. Let's at least see a live witness," which now, thank God, you could do remotely
mm,
because I have most of my witnesses are not in the state of Nevada, so they can come on screen just like I'm on screen with you, and they can testify. They can take the oath and then authenticate the documents and submit it for judgment.
but you have to go in person to the court, or you're also on screen.
I I almost always go to court in
Mm,
person,
okay.
and if I am not in court in person, there's usually a very good reason for it, and that good reason would be the judge telling me, "No, I don't want it. No, I prefer you to appear remotely," which has only happened like up in Reno. A couple of judges said, "No, we prefer remote." Um, I know bankruptcy courts I don't know if it's everywhere, but bankruptcy courts, they don't have any in-person appearance. Everything's by telephone. And that's been going on about 5 years, I guess, since COVID. Uh, I've had one time I had to be out of town for a routine status. And so I did it but otherwise my tuchus is in court in
Okay.
person. That's my custom. It's important to me. And the fact is my office is barely a block from the courthouse. And I wanted to be there. And even in COVID, as soon as they let us in the courthouse, I was in court.
No,
And
I'm the
I did not
opposite.
want.
I have no interest in going to court. I started practicing really, in kind of small firms. It was COVID, so everything was remote anyway. I just got so used to it. I don't go to court unless the court orders it or it's an evidentiary hearing for a few hours. It's just what's the point? Maybe it's because
Well,
Miami, I gotta schlep a lot with
see, I
traffic.
think that's a factor. Now, if you're in Miami, you have courts downtown Miami. You have courts downtown Fort Lauderdale. I don't know Florida that well, but I imagine you have your district courts are all
Yeah, the
in
main
the
court's right. It's downtown Miami. That's an hour drive, and Fort Lauderdale's a half-hour drive. And, yeah, so
right. So I could see in your situation that it doesn't work. In my case, as I said, Clark County, it's a little bit different. Clark County is where Las Vegas is. It's a very big county. It is very big. I mean, if I was to drive to the next county, one county is 60 miles in one direction, which is almost, and if people don't know, if you look at the state of Nevada, it comes down to a point. That point at the bottom, that's where Las Vegas is. Not the very, very bottom point, but around that point. So Clark County is huge. And so there are only, whereas you in Florida have what, 67 counties? Is that right?
I
Something
don't
like
know the
that?
number offhand.
Yeah. And so I think I remember that from going to FIU. I seem to recall that, but I don't know why that number's in my head. I just made it up. But Nevada maybe has 16 counties, and most of them are what's called cow counties. And that's not a mean thing. That's what they call themselves, cow counties. You have the main cities in, Clark County, Las Vegas, and so the courthouse, I said, is a block away. Otherwise, you have Reno and other courts too, and it's but so it's a little different. So there really isn't fighting traffic to go to different courts, even though there are other courts around. I've been to Pahrump, which is in the next county over, and again, that's a 60-mile or so drive. But anyway, but yeah, no. So I prefer it. I think it's important, and I can see in your case where it's you didn't start off doing that. I just like I just like the feeling of being in court. I feel like I have a little bit more control of my case. I like having that relationship with the judge, so we are looking at each other, being whatever we are, 20 feet apart, uh, and whatever that is about, a little more than 20, but that to me is important.
All right, cool. So one of the things I do is creditor side bankruptcy practice, which I think a little bit is overlooked in collections practice. I think most collections attorneys, when they hear bankruptcy, basically just maybe file a claim, if that, and just shut the file down. What's your practice? If one of your debtors files for bankruptcy, how do you handle it?
I do. I know when I go to the commercial law league events, which I do go to many of them, and IACC events, they always say, "Hey, if you file bankruptcy, it doesn't mean you close the file." Yeah, that sounds good, and I understand they're trying to give the options. The fact is, when bankruptcy is filed, there's an automatic stay, and if you want to go beyond that and you want to litigate to challenge the discharge, that's complicated litigation because I have done that in the past. So really, I that pretty much ends my involvement in the case. And sometimes I have clients that say, we want to file the proof of claim, which I say it's okay. And they do that obviously because they want to be the one who gets paid. And then, sometimes they'll give you a little piece of it, but otherwise the money goes to them. And so sometimes they say that. Sometimes they ask me if I want to file the proof of claim. And if it's an asset where they say file the proof of claim, and sometimes I will, I've done it before, and your inbox gets flooded with all the filings in a bankruptcy that you're really not involved in. But yeah, I would say for the most part, to be real, when you have a collection case, the bankruptcy is filed, the case closes. Unfortunately, by the way, the judges, not the bankruptcy judges, the state court judges, they have you give status reports every few months, which is a little bit, you're really being drained because your file is closed. You're not collecting any money. Right. And but the bankruptcy court, but the state court will say, what's the status of the bankruptcy? Because the state court judges don't like to have, if a case is dismissed or in judgment, it's closed. If it's a bankruptcy, it's not really closed yet. Right. So they will say, okay, every few months you got to tell us what's going on. I'm thinking, but it's good you have your bankruptcy experience because you could litigate in bankruptcy if you think that there's a basis to, as I said, challenge the discharge or fraudulent whatever it may be.
Yeah, no, I mean it's definitely a lot of work going into a bankruptcy, and it has to be the right case. If it's what I call an honest bankruptcy, it's kind of to go into that is really hopeless. But sometimes these debtors, it's bad faith or kind of questionable why they're in bankruptcy. So in those cases, I think sometimes it's worthwhile making the challenge. But yeah, definitely a lot of work. If I keep developing it, I'm gonna have to figure out how to kind of structure that with clients. But yeah, we'll see. That's for down the road. So maybe some more just background or general questions. So collections definitely has a bad rap out in the big wide world, particularly consumer. I mean, you don't do consumer, but you know, most people don't distinguish. How do you respond to the criticism?
Right, and it does, and I think I think across even commercial collections, even across the board, uh, you have you have a you have a sense that people want to be protected from creditors. Of course, if somebody's owed money, then they don't want to. But so the answer I say is that, and by the way, Nevada is the most anti. I know there are a lot of anti-creditor states. I know Florida is known for having the unlimited exemption. It's legendary. Nevada has not an unlimited homestead exemption that when I meant unlimited exemption, I meant the homestead. Nevada has one in essence because they put it so high that it is unlimited because I mean there are $17 million homes in Las Vegas, but that fall over. But anyway, so what I say is the fact is what we do as creditors attorneys is very important, and we are the basis of of disputes between people in a civilized society. You cannot resolve disputes in a case without having a it resolved through courts of law. Now I know Tuvia, they say you're Jewish. I don't know much about you. No, just picking on you. We say one of the seven mitzvahs that is on the non-Jewish people is to have courts of law, and the courts of law where people can resolve disputes and respect the institution. That is the basis of any civilization. And what's the biggest cause of a dispute is somebody owes me money. And you have two ways to resolve it. One, you owe me money, and you take the guy and Nunzio with the baseball bat beat you to a pulp till you show up with that money. That's not good. And we
That's not
don't want that.
civilized. Yeah.
That's not civilized. But we could say, no, we need to go to court and we need a judge to tell the person, excuse me, judge resolve the dispute with a written order and then be able to enforce that order and be able to attach assets to satisfy that judgment. We don't have, thank God, we don't have the violence in the streets because we know we have courts we respect. And if somebody's owed money, there's a right way to handle it. You go to court. You don't take matters into your own hands. If you've exhausted all reasonable efforts to say please pay, no, you have to go to court, and the institution, society's institutions, handle it to the best they can. And I think it also takes away. I think when institutions say we're going to increase all these exemptions, well, all you're doing is you're taking away the power of people to resolve their dispute. And I think it's backwards because, as I said, Nevada also goes backwards. So no, they keep increasing the exemptions. I'm saying, well, the people you're protecting are the bad guys. And I know in their minds they're thinking, no, if you're owed money, you're the good guy. No, it's not always like that. People owed money because they owe the money because they legitimately owe the money to somebody, and they shouldn't make these laws up that say, okay, no, we're preventing you from making yourself whole, that's what these exemption laws do. And so when people say they're anti-creditor, they're thinking, and I'm anti-creditor because I don't want the credit card company hounding me. I don't want this medical this hospital hounding me. I get that. And by the way, I've been on the wrong end of not so much credit cards, but unexpected hospital bill, God forbid, and you're on the wrong end of that. That's happened. And when it happens to you, you're thinking, you know what?
Become a debtor lawyer.
Yeah, screw the whole damn institution. We need to turn this thing over. No, but I can see where people get that way. So no, to have a collection attorney who can go to court for you and through the legal process collect your money or satisfy your judgment, that to me is what keeps the violence off the streets. We serve that important function. You don't want a society without the collection attorney doing what we do to help those who owed money and to resolve disputes.
Interesting. Yeah, I like that take. It was an interesting point that you were making. Also, I haven't seen this in Florida, but it sounds like out in Nevada they're raising exemptions. I mean, the people the people those are protecting are the millionaires who obviously can pay their debts. So like, what's well,
Nevada has so many categories of exemptions that the exemption statute, it goes from like A, B, subsection A, B, C, D, and then it goes to double A, double B. And I think it's it's well, I don't even know what letter it's at. And they keep raising them, adding more, whether it's raising the homestead exemption. And they always say, oh, the homestead, it's a person's house. Okay, I get that. But, you know, how much, it's pretty high. The legislature really thinks all these homes are very expensive homes, but also too at this in Nevada, there's so many classifications of exemptions, like whether it's heirlooms, tools of the trade, you know, art music. I mean, it just there's some crazy stuff, and those don't go away. Nobody says, "Come on, who's got? If you have this, you should be able to pay your bills." No, so I think it's one of those things where the liberals like it
Mm.
because it's protecting who they see are the, so to speak, the little guy. But the conservatives like it too because they think it as, hey, you know, there's sort of a populist aspect to it. Hey, you can't don't come for my art museum, museum, or whatever it is in Nevada statutes, whatever it is. There's some crazy exemptions, and so you have on the right too, like you don't come for my whatever. So it's almost like both sides come
Don't
together.
don't tread on me.
Yeah, exactly. Yes.
Interesting. Why art is exempt out in Nevada? I had a case in
No,
Florida. Yeah, go ahead.
no. It's not exactly. There is an exemption for it, but yes, it's more specifically worded. But yes,
Well, I had a case here where we got a foreclosure judgment on an art museum. So I don't know if that would same thing or
right. And think an art museum, why should they claim exemptions at all? They're not even a person,
yeah.
So, but it's crazy it's crazy how businesses could try to claim an exemption. That to me is insane.
Yeah, that's a good point. Yeah, no, out here in Florida, like for a garnishment, the business you don't even have to serve a notice of exemptions because there are no exemptions for businesses. So
Right.
interesting to compare. All right, so just to wrap up here, what's your greatest success story?
Boy, thank God I have them. I'll tell you one just came about last year or so. I had a case where I filed suit for it was goods. In this case, it was ammunition to a gun store, and the attorney calls me and he says, I forget what he says. He says we have to talk about when we win the case. This is the opposing attorney calling me. When we win the case, we'll have to talk about how much attorney's fees you're going to owe my client because my client says they didn't get delivery or they paid for it already or whatever it was. It's like, okay. And I talked to my client. They said, no, I'll tell you that the case is valid. So and the case was for like 160,000. It was up there, maybe
A lot
100.
of ammunition.
Yeah, a lot of product. And so I said, you know what? Client says it's valid. And this guy, of course, is, part of the word, no, we didn't get it. We already paid it. We already paid it. We went ahead and I drafted a motion for summary judgment where I detailed, first of all, I briefed the UCC on sales of goods. And that was important to, spell out the statutes where are relevant to payment. And then I showed invoice, deliveries, bills of lading, brief that, and credits, and put it all together where the judge could understand it. And here I was, filed the motion, and I don't think the other side was expected. Got to say, in a way, I was not necessarily expecting. Judge says, you know what? I think you laid it out. I don't see tribal issues of fact on your summary judgment. I'm giving you summary judgment for whatever it was, 160 or so thousand. And the attorney called, and I tell you what, it was great because the attorney called me and said, same attorney said, we have to decide how much you'll pay me in attorney's fees as soon as this is over. He said, okay, listen, my client doesn't want a judgment against them. Can we? And so we negotiated. Eventually, thank God, they paid not the whole thing. Of course, like with any case, and this is important as a side note, you're never getting everything.
Yeah.
So definitely, even in a case like this where you win and you have a solid case, and even if they got appeal, they're not going to do much. They're more than likely not going to. But even so, give a little bit of compromise, and they paid it out. And that was nice to get a settlement. I forgot what the settlement was, but it was as I said, it was not the full amount. We gave a little, a little compromise, give them a break. They save face and end up getting a nice big settlement. And the commercial cases where some settlements are $500 payments, and it's nice to have one where it was into the six figures.
It was just one check.
No, they did it by wire, and I remember the wire was
Oh.
so big they had to do it in two tranches.
Okay.
So, uh, so those are nice.
Yeah.
Those are nice. That to me is those are the good stories where you really, and unfortunately they're few and far between because you're not settling cases for six figures every day, but it happens, especially where it happens when you had to fight for it, and the other side was coming into it saying, we'll see what you're going to be paying me in the end. And no, they paid us in the end.
All right. I think that's all I got. Thank you very much, Peter. And if you want to check out Peter's practice, where can they visit your website?
Good. Dubowskylaw.com, Dubowsky, Dubowskylaw.com. I practice exclusively in the state of Nevada, but I do cover the entire state of Nevada. So if anybody is, I'll take cases to litigate against parties in Nevada. So thank you very much for that. And I wish you luck in your practice and
Thank you.
podcast.
Yeah, thank you. And that will conclude our inaugural episode. Thank you very much.
Thank you.